So, hi, everybody. I am here for you. I want to educate the public as an attorney. One of our core principles is to be a counselor at law, meaning to counsel the public on understanding the consequences of decisions, whether they're good decisions or sometimes less than wise decisions. So here, just so you know, like I am a real lawyer licensed in Florida. I've been practicing law for almost 17 years. I have my doctorate degree. I have an MBA. I have a master's of law and taxation. I am a big nerd, but I'm also a mom. I'm a wife. I own a business. I've written 4 books so far. And everything that I do because I enjoy teaching people on how to make better choices that are going to impact their family, going to impact themselves for the rest of their lives. And so it brings me joy to do this for a living. Okay, as Justin said, type your questions in the chat. Take notes. If you have notebook paper with you, please, I encourage it. There is also a little tool that we have. It's going to be through a QR code. You'll see it in the presentation. It's called a legacy leak test. Okay, this is to help you. It's more to help you have the right conversations with your loved ones about identifying the gaps in what you do have presently, or if you have nothing, about addressing those items one by one. Okay. All right, so why are we here? We're here because as a result of people not understanding the consequences of poor planning, we have in the United States $70 billion in assets that are all stuck in what we call the departments of unclaimed funds of every state in the country, right? Florida alone has over $2 billion stuck, frozen there. And the vast majority of the funds there are as a result of people passing away without a proper plan, okay? And it's maybe because they thought they had something and family can't afford to go to probate. It might be because they had nothing. It might be because they didn't know how to communicate what they had to their loved ones. And so these are all reasons for which we pay what we call this involuntary tax to all of the states in our country. And I don't know about you, but I do not want to pay involuntary taxes. I want those assets passing to my loved ones and not to the states. Okay, so I want you to understand this meeting is for you. It's going to be interactive. You are going to have activities. Why? Because I really want you to think through all of these very important topics and discuss them with your loved ones. It is, I mean, you know yourself best, you know your loved ones best, you know your situation best. So I'm going to help you out. I'm going to walk you through. Julie is going to put into the chat the worksheets for you to complete these exercises. Don't worry, every answer that you submit is private, it's confidential. Nobody sees it, okay? It's for you. All right, but we're going to have 3 exercises that we're going to start with because I need to identify where's your starting point, okay? Number 1, we're going to talk about incapacitation. And I choose to have this one be the first thing that we address, incapacitation. Because too often when we think of estate planning, we're thinking of dead people. We are not thinking of the fact that some car accident, some disease, right, can leave us incapacitated. And that means we're still alive. That means we're still suffering the consequences of our action or inaction, of our decisions or indecisions, of the resources we've left behind or left frozen. And so that's why we're going through these first. Okay, so number 1, right? Who would care for you if you suddenly fell into a coma tomorrow? And I ask this because many of us have family members that would raise their hands, and it might be the person that you least want to be involved. An older sibling, a mom that you haven't talked to in years, a son who thinks he knows everything about you, and maybe you have very different values, right? It's important to understand who would raise their hand and if they'd even be the right person that you'd want raising their hands, okay? So number 2, let's say even the right person raises their hand. Would they know where your assets are? Because if a person, even the right person raises their hand, they want to help out, they want to be your guardian, okay? If they don't know where your things are, it's going to be an incredibly hard process to be able to get assistance for you. Okay. So that's big. These same individuals, do they know your needs? Do they know your medical issues, your medical history? Do they know your allergies, both to medications, to food, right? Because if you're hospitalized, you get fed, right? Do they know this? And if they don't know this, there's a talking point to begin with the person that you might want to actually step into the role, okay? The other thing is, do they know how to access the funds, the resources that you may have to take care of you in incapacitation? Because those bills don't stop, okay? Including the bill of the IRS. It doesn't stop. And we don't want to make those people have to take money out of their own pocket to be able to step up, right? It's our responsibility to provide for ourselves, okay? So if many of these answers are nebulous right now, or they're giving you little red flags, you're not really protected at the moment, okay? Because the courts do not care about what you think your family thinks that you would have wanted. The courts do not care about, well, this person's a lot more loving and warm and caring. They care about the economics of it. What's the value of the assets? Does this person look good on paper? So yeah, it's not necessarily going to be the best for you, okay? All right, exercise number 2. For those of you who are parents or who are caring for an elderly parent or an elderly loved one, okay? What if something happened to you tonight? Who steps in to take care of those people? And I ask about elderly parents because there are a lot of us in Florida that have parents that have moved from northern states and they now live with us or close to us. And we tend to become kind of like the general managers and supervisors of those loved ones. And then often the more intensive caretakers when their conditions advance. So just as much as it's necessary to know like who would step in for your children if you cannot be found, if you cannot be located, it's the same thing for your elderly parents, okay? Do you necessarily want the police to be the one taking custody of your child or your elderly parent? Probably not. One of the things that you need to understand is that the vast majority of sheriff's offices in the state of Florida do not have a uniform policy for what to do in the event that they're picking up a minor child or picking up a potentially endangered adult because, they have incapacitation issues. This is problematic. And I'm not kidding, okay? The vast majority of sheriff's offices don't even have a standardized practice for writs and eviction cases, okay? So they don't have practices that are standard for much of anything when it comes to civil matters. And that puts your loved ones at risk because the worst thing that can happen to your child if you have a minor is them losing you as a child. That's a very, very impactful circumstance. And you probably want them to be surrounded by loved ones that you trust and care about. But if you don't empower them to do that, there's going to be problems, okay? Now, even if you've talked about the right people to step up for caring for your elderly parents, for caring for your children, do they know your parenting or caregiving values? Do they know the structure, here's what we do as a daily routine that helps emotionally support your child or your elderly parents? And for people that have memory problems, routines are incredibly important, right? Because they rely on that to not get lost in their environment. And finally, the people that would step in as caregivers that you want to step in, do they have access to the right finances to support those wishes that you have and those people that you love? Because again, it is our responsibility to provide for the care of our children, okay? And it is also our responsibility to provide with clarity to other people that are not in charge of our parents, of our elderly parents, a good guide as to what resources those parents have available for their care, right? And At times, elderly care can be a lot more, okay? Nursing homes can cost anywhere between $6,000 to $12,000 a month. So understanding those resources and having a plan in place for are very important. Okay, exercise number 3. What happens the day after you die? Okay, the day you die, everyone is in shock. People are grieving. The day after you die is when the realization comes of like, I have things, something needs to get done. So again, somebody will probably step up, raise that hand to handle things for you. It's not necessarily the people that you want. It might be somebody that's interested in the money. It might be somebody that was kind of shoving deep down into their core disagreements that they had between the siblings, and now they want to step in because they want to have control over things. And so we need to make sure that the right people are in place. Similarly, it's very difficult for people to know where your assets are. Many of us don't tell our loved ones, hey, yeah, I have an account in Bank of America. I have an investment account with Fidelity. I have another one at Raymond James. We don't share that information, okay? We're very private, us Americans, right? And so we need to be mindful of the consequences of not having an organized system in place of where our assets are, because those are the resources, not just incapacitation, but to take care of our family after we pass. Okay. They also might not know what on earth you prepared while you were living, if you prepared anything. I say this because we get many phone calls, we get copied on emails where hundreds of other attorneys are copied, where it's just desperate people, siblings, children, etc., asking, are you the firm that created the will for my mom? She said that somebody created a will for her, but we have no idea. Okay. You don't want to have your family be doing that. And then, of course, do they have the funds to open up probate? Because probate is costly. And we'll talk about that a little bit more later. But liquidity is a real issue. It's one of the biggest reasons why we pay that involuntary tax as a society, that $2 billion that ends up going to the coffers of the state of Florida, or $70 billion overall. Okay. We also need to understand that if we don't know who we're naming and whether they qualify or not, they might just be completely blocked by the court. Okay? Just no authority whatsoever. So, having done this exercise now, okay, is where we're going to start understanding. Is it okay to just have a will after going through these points? No, not unless you want to deal with chaos and a mess and have absolutely zero in place for incapacitation, okay? Wills do not allow free use of assets, okay? It's not like what we see in the TV shows and the movies where there's some lawyer in some big office and like he's pulling a scroll or a big binder and saying, and to you this, and to you that. That's not how it works in real life. In real life, a judge would be in charge of even allowing that will to be a real thing, okay? They have to allow it to go through. And it's whatever the judge allows as a process through there. So it has to go through court. It's not an out-of-court thing, okay? Wills, no protection for incapacitation. They're not, a document isn't going to give you tax advice or tell you how to minimize the risk with creditors or tell you how to properly incorporate having somebody that takes care of your children. If you're a business owner, wills don't keep your business running, okay? And the bills don't stop, the clients don't stop, the claims don't stop. So it's really important to understand there's going to be serious cogs if we just depend on a will. Okay, I think that you and your loved ones deserve better. I think everybody in the state of Florida deserves better than this will thing that people have been sold, or the only thing that they've ever been informed about. Wills don't sign documents for you. Wills force you into court. They almost always force having to pay a big fee called a bond to the clerk of court. It is incredibly seldom to see a will that actually handles the immaturity or minority of a beneficiary. special needs of a beneficiary, or even protecting beneficiaries from potential creditors like ex-spouses or soon-to-be ex-spouses, okay? Wills do not stop lawsuits. They require a lawsuit. And half of my practice is litigation. Listen, if we can avoid litigation, you're on much better plan, okay? It's better to avoid litigation whenever possible. What kind of person is served by better planning? Well, everybody, okay? If you're a widow, if you have children, if you own a business, if you're part of a blended family, which, by the way, is the majority of American families now. The majority are blended families. If you own real estate, if you're in the sandwich where you've got maybe some young adult kids, but now you're starting to take care of your older parents, you deserve a better plan. So let's go over what some people think planning is, and then what the options are out there. So a lot of people think of planning as documents. They think of a will, they might think of a power of attorney or a healthcare directive if they've been given a little bit more guidance about incapacitation. They may have been told about using, a type of a deed or two. You see it all over the Facebook community posts. So many people reaching out to non-lawyers for legal advice. And so they're getting all of this. No, have a will. Oh, you need this. Oh, you need that, right? But the truth is, paperwork done poorly will lead you to court. It creates a mess, and it is the most expensive to fix. I'm going to give you a parallel example. We had somebody reach out to us recently. They had hired a lawyer who had charged only $500 to do a lawsuit for them and told them, oh yeah, it'll be done in 90 days. These lawsuits, by the way, usually $3,000 to $4,000 is more of a reality for doing it per property. And now the case has been happening for over a year and a half. Nothing has moved along. The court has sanctioned the lawyer for what has been created. So cheap is costly. As we say in Spanish, lo barato sale caro. Okay, so it's really essential to separate documents from what planning is, because documents are tools, but knowing how to create the right tools, that involves real planning. All right, here are your options as to what's out there. You need to know. Number one, the court system. Okay, the court system is either you went with a will as an option, or maybe you didn't go with a will, you didn't go with anything. Okay, you decided, I'm not going to spend any money on planning. I'm just going to rely on the Florida statutes. It is the most expensive way. To give you an idea of like fees, if you have an estate that's worth 750 grand, okay, the value of a regular house, about 400 grand, and maybe some retirement accounts, some investment accounts, bank accounts left over. The cost for that kind of an estate in legal fees can easily be about 60 grand without the judge having any qualms about the fee being charged. It is incredibly expensive. And that's if nobody bickers, if nobody fights, and if somebody happens to have the cash on hand to pay the attorney that for the hourly rate. Because the non-hourly rate means somebody has to rely on contingent lawyers. Who's accustomed to seeing those billboards, right? Like, you'll pay nothing unless we win, blah, blah, blah. Those are contingency lawyers, okay? The majority of lawyers are not contingency lawyers. It's very hard to find a lawyer in probate matters that will do it on contingency. And if they do, they will take a chunk that is very big. I'm talking like 30% of the value of the estate. So it is the most expensive process. The other part is that there is a bond process. Bond is because the judge says, hey, I'm putting you in charge of all these assets. I don't want you to run away with them. And if I don't want you to run away with them, I'm going to make you pay something so that you stick around with those things. But the court doesn't really take much care of minors. It just says at 18, bam, you get everything. And who knows of a really responsible 18-year-old? It invites challenges, okay? The more errors that are out there or erroneously made documents that now create potential beneficiaries, the more people that come in to challenge things. And of course, it'll build resentment because being the person that's appointed to run everything in court is very hard. It's taxing, okay? You are constantly assigned things to do because we're on a timeline. There's statutory requirements all along the way, whether you have a will or not, okay? That's option one. I don't know if you like that plan. I don't like that plan. I have to litigate that plan sometimes, and it's not the best. Option two, online forms. This is like the cheapest one, okay? It might be LegalZoom. It might be that you decided to ask AI to create things for you. Okay, I'm going to tell you about the risks here. Number one, AI frequently hallucinates on legal matters. What do we mean by hallucination? It just makes things up. And unfortunately, some less than scrupulous people in my profession are starting to use AI to draft pleadings, and they don't know, or they don't care, that the AI is making up cases, it's making up rulings, it's making these things up. We lawyers have, access to the places where we can verify if a case exists or not, or what it says. You do not, okay? So you have no idea if what they're creating is at all valid for the state where you live. Two, the other thing is, AI pulls from any and every resource. The same thing with online forms. They kind of standardize them based on what they think the majority of states do. That doesn't take into account the very many nuances that exist for Florida, okay? One of the biggest changes, for example, that we had is the UFIPA came into play, the Fiduciary Income and Principal Act, a totally different way of calculating like what's income, what's principal, to what beneficiary, et cetera, under our statutes. AI and online forms, they have zero accountability, okay? If they make a mistake, you don't get to sue them for malpractice. They also are not going to give you guidance because they're not lawyers. These are just machines, okay? The machines will give you paper, which is riddled with mistakes and hallucinations. And mistakes are, again, the most expensive things to fix. So what could have been maybe a $60,000 estate if you did nothing, no forms online, will turn into a $120,000 mistake easily because of the things that have to be litigated. I don't know if you like that plan. I'm not a fan of that plan, okay? It gets a lot of people in trouble, and it's not effective. Option three is what we call door lawyers and high volume firms. Okay, so there are two things. Door lawyers. What do we mean by door lawyers? They take any case that walks through the door. They are an expert in nothing. Okay, so they'll do criminal law and a family law case, and then they'll prepare a will, and then they'll do the PI thing. They'll do anything and everything that comes through the door. That person is going to mess up on everything that they make for you because they have absolutely zero expertise in all of the areas in which they practice. It's very dangerous. It's also very easy to challenge things that are not well made. The high volume firms are the ones that will charge you between, I don't know, $1,500 to $2,000 to create an estate plan. It's just documents they give you, but they do it really quickly. Okay, you get like a half-hour meeting to kind of design like who's going to be where, right? They don't have the time to examine family dynamics or taxes or the effect on real estate here and in other states. And maybe if you have a business or your minor children, they'd have zero time for any of that because their bosses require that they have this quota that they meet, and they got to get all those done within that weekly quota. And that means that you are getting very little focus on what's being created for you. So just paper. They also don't do any funding for you. They don't put any assets in the trust, which means you get a heavy paperweight, okay? An expensive paperweight that is meaningless because unless you fund whatever plan you're creating, it has zero legal effect. It's as if you had no plan. Again, I don't know if you like this plan. I'm not particularly a fan, and I wouldn't do that for my family. Option four, we call it big law, okay? Big law are like the Trenum, Kenker, and all those big law firms. They have highly specialized lawyers in different areas of the law. Okay, so this one lawyer only does this other lawyer only does this. And so they're not door lawyers. They might have lots of different practice area, but they have specialists, except that those specialists are going to be expensive. It's usually hourly, and you can easily have a specialist charge between $400 to $1,000 an hour to work on things for you. But the problem is that they assign the important matters, the wealthy clients, to the senior partners, the ones that have the real expertise. Otherwise, they're going to assign a very, very tired associate to handle your thing, still for a very high hourly rate. Okay, those hourly rates don't really go down much. But these are people that have such huge annual hourly rate requirements that they're working 70 to 80 hours per week. You have tired people working on your things, you're going to get a mess. Sometimes they do funding. I've heard from clients that brought me things that they didn't do funding for them. They paid $8,000 and had absolutely zero assets transferred into their plan. Okay. These places, you can, to do a proper plan, they might charge you between $20,000 and $100,000. They are mostly for wealthy families. Okay. You can choose that option. You are probably going to get a specialist indeed, but you're going to get a tired one unless you're up high in the millions. I'm talking like you're already in the estate tax bracket. Okay. Option 5, the non-lawyer services. I cannot tell you how many different post people, etc. I see out there. They're like, oh, my financial advisor said that they can do my estate plan for me, or this notary can do it for me, or my church has brought in a person that's going to like offer estate plans and they're only going to charge $1,000 to do the plan, etc. And sometimes CPAs get involved. First of all, these people are not licensed lawyers. They do not have specialized legal training. They have no idea if they're making mistakes. Second, that financial advisor, that notary, that church associate, they have zero liability under professional regulation rules for the mess that they create in your estate plan. None. Okay, so you can't go sue them for malpractice because you relied on a non-expert to create something for you. What they are doing is actually called the unlicensed practice of law, which is in actuality a crime in Florida. Okay, so should they be involved in doing planning for you? Absolutely not. One of the most jarring things that I've seen in the church associate plans, yeah, they'll have a lawyer that does it, but in every single one of those plans, for you to get it for $1,000, you have to leave your assets to the church, a certain percentage of your assets to the church. Okay, so it's a false sense of security with very poor guidance that isn't licensed to give you guidance. And in my opinion, you're better off not planning at all than having any one of these people do it for you. Options. Here's what we offer, okay? And there are maybe 600 firms around the country that do this system. It's called legacy planning. It is very, very different because it's not an hourly fee thing. It is not a we're sitting down with you for 30 minutes thing. It is you are our client for estate planning counseling for 3 years. 3 years, yes. You have very long planning sessions, design meetings, and review meetings. The purpose of doing that is because you need to understand what is coming into play. You need to understand what you're doing. You need to understand the consequences of it, and you need to understand it in human words, right? Not in legalese. You don't need to become a legal expert in order to have an understanding. You just need to have somebody willing to walk you through the process. One of my biggest frustrations when I go to like the local bar lunches and everything is that there are multiple estate planning attorneys, the ones that do it the traditional way. Let's call them either door lawyers or the high volume ones, that have made this comment before. Oh, I was so upset because the lady, she came in to sign and she expected me to explain it to her the whole time and just sit there, and took an hour and a half. And I'm like, you are a counselor at law. Why would you not explain what your client is signing and the consequences of what your client is signing? What will you ever have them sign something that they don't understand? Okay, my opinion, that's malpractice. So we do it a very different way. We also create inventories for our clients so they have a structured, organized place where everything is in case something happens to them. Their agents, the people that they trust, can come to us and say, okay, what did this person have and where, right? And we train you on updating that. That's part of the 3 years thing. I don't know if you've held like the atomic habits, right? You got to repeat things in order to make it part of a routine and make it part of something that you understand. You got to repeat it. So that's why we do quarterly asset inventories during those 3 years. Same reason why we do monthly funding guidance for a year, because we know life gets in the way. You don't know necessarily how to fund things and put them into a trust. And that's why we're here. And it's very specific. It's tailored to our clients. And then we also have video trainings. I always like adding to video trainings. Why? Because not just you, but the people that you're putting into these roles, they have no idea what they're doing. They need guidance. Okay. That's what we do. And it's different. These are just some of like the reviews that we have. By the way, we have all 5-star reviews. I pride myself on having one of the most amazing teams in my firm. They're sweet. They follow through. They're very kind. They're understanding. They treat you like a human being, which is really important. Okay. So I take these to heart. These are golden to me because I want to truly be a counselor for my clients. And the thing is, once you've passed away, once you've become incapacitated, you can't plan. Legally, you are not allowed to plan at that point in time because you don't have capacity. Obviously, you don't have capacity if you've passed away. There's no weekend at Bernie's planning, okay? And you don't have capacity if you're incapacitated, okay? If you can't think or function on what your assets are, etc., you can't do it. And this is one question that a probate judge discussed with us when he was talking about everything he sees in the probate cases and what comes up. And he goes, man, I'd love to say, these people that passed away, how much would you pay the right lawyer to actually bring you back from the dead and fix this so your family would avoid everything that's now coming before me? So why do we not focus on documents? Okay. Documents do not help you select the best people. They can't. Documents do not help you understand tax line lines. Okay. There are so many times that I've seen people have like a kind of trust A, and they had no idea about the tax consequences involved with it because the person that created it for them had zero advanced tax training. Documents do not prepare agents for what they should be doing if you become incapacitated. Documents do not navigate the complexity of human relationships, whether it's because there's a blended family, whether because you have a child with special needs, whether because you are a serial entrepreneur. All those things come into play. Okay? Documents don't do that. Here are some of the very cheap planning mistakes that I see. Okay. Number one, people have, they add their son to title, their daughter, sometimes their sister, etc. Joint tenancy with right of survivorship. The moment you add a person to title to your property, you are welcoming their creditors. Okay. Because they have title now. They also now have a say in leasing, renting, selling, mortgaging, etc. You have just given command to another person over your things. Okay. Life estate deeds, even ladybird deeds, those can be problematic, mostly in the event of challenges. Okay. Many times I see that like the ladybird deeds, or where it comes to litigation for me, is that the ladybird deed was maybe signed by somebody who was in their late 70s or early 80s, and maybe they put in a grandchild and all of this, and that opens it up, especially because they didn't do it with a lawyer. It opens it up to this person and this is the grandchild and this son and all these people challenging it. Okay. And they're right to challenge it because having a ladybird on its own can be a red flag. about abusing an elderly person or taking advantage of an elderly person. So that's one thing. The other thing is if the person becomes incapacitated, they are still entitled. They are still govern and control everything. And if you have zero plan in place, nobody can sign on your behalf to do absolutely anything with that property, right? Sometimes people also make mistakes as to who they appoint as the agents and trusts. If you've got everybody's the same person in your trust managing everything, they no longer have creditor protection. And maybe you thought you were giving them something that protected them against their creditors, okay? So these common things can result in expensive and painful real things, real litigation, real disputes that I see on the daily. Legacy planning, okay? Legacy planning is strategy. It's coordinating whatever tools you create, okay? They all need to coincide with each other. It can't be like this random will and then this weird disconnected trust here and then this power of attorney that doesn't address absolutely anything having to do with what you've created elsewhere. It needs to be coordinated. You need guidance. You need guidance because this isn't something that you do day to day. I am sure that whatever you do for a living, even if it's just taking care of your children, which is a lot, you are an expert in that. You are not an expert in doing estate planning because it's not what you do on the daily. So getting guidance from a person who's an expert will help you make the right decisions. It'll help you reach an understanding faster. It'll save you time, okay? But again, that's not documents. That's having a real system in place. And that's only something that you can get with a specialized counselor at law. This is the tool that I was telling you guys about. Right? So we had the quiz. That's a tool for you. And now the legacy leak test. So you can click on the QR there or do the little QR thing. Julie can probably put a link on the meeting for you to take this test. It is super easy, okay? It's just a series of questions to help you identify where you have gaps in your plan. You get results very quickly because, again, it's just 15 like yes, no questions. But the idea is to help you understand, are you even a right fit to maybe work with us, okay? You might not be there, and that's okay. But it is important to know where are the holes and the things that you need to talk about with your loved ones. So there's the legacy leak test. The reason why I bring up the legacy leak test is because as a counselor at law, it is my duty, okay, as an officer of the court, to encourage you all to do things that will keep you out of court, period. So no matter what, if you can avoid the state's plan, please do so, okay? So this legacy leak test is just there for you. If the results tell you that you might be a good fit for us, for talking to us, for having a conversation, then, okay, just today, you can get a 15-minute golden ticket discovery call. It's free, right? It's just a quick call with my team to see if we're the right fit for you. It's okay if we're not a good fit. That's fine. I don't expect to serve everybody. That would be foolish, okay? So for example, who's not a right fit for me? People that want to do elder Medicaid planning. I don't handle Medicaid planning, okay? So I'm not going to be the right fit for you. And that's okay, right? I also don't do emergency planning. Okay, so we had, for example, somebody call in yesterday and mom's at the hospital on her deathbed. We need a plan, blah, blah, blah. Sorry, I don't handle that. I don't do rush things. Rush things get challenged in court very, very quickly. And I don't want to cause chaos for family. So just so you see, like, what are we the right fit for? We're great for people that have real estate assets. We are wonderful for people with children. We have clients that have children with special needs. We have clients that are business owners. As a business owner and business nerd, I understand the additional things that need to be managed, especially if you have partners. But this is the opportunity to just see if the call works for you. If it doesn't, that's okay. If it does, wonderful. I'd love to see you with having a legacy planning session with me. And those are completely detailed to you and your assets and your family. And they're at least 90 minutes. And I tend to go over, you can ask my team, because I really care about understanding and learning about that, each person's family and their dynamics and their lives. Okay, let's talk about the different types of court in more depth, because I want you to understand the processes that are out there. So one, guardianship court. So this is if a person's incapacitated, and to a degree, what children will have to deal with if they lose their parents, but it's a little bit different for kids. If you're incapacitated, it's not a great place to be. One, because it is quite a bit of money to just open, not even to get through the thing. Generally, the average fee to just open guardianship proceedings is about $10,000. The proceedings last a long time, because so long as that person's incapacitated, you are stuck in the court system if they didn't have a plan in place. Judges rotate, and so you may have had a judge that understood the case and understood why this had to be done, and this care plan was being provided, and now you get a new judge that's like, I don't like it. We're going to do something different. And your whole life goes, what? There's no cap on costs and fees in these cases, okay? Guardianship cases can go on for decades. Think about how long Britney Spears was under guardianship, right? If you are subject to guardianship proceedings, you do not have basic rights anymore. You can't vote, you can't drive. There are so many things you can't do. And many times guardians are not well supervised or trained. If you're a guardian for somebody that's incapacitated, all you need is 8 hours of training. That's it. And then they'll let you loose on a person. It's so bad with the professional guardians that a committee was established maybe about 5 years ago to supervise the complaints that people were submitting about professional guardians. And they did an audit recently, I think at the beginning of last year, to see the results of that. The results were that even though 60-something% of guardians had received complaints, 0 had been held accountable for their actions. Okay, so guardianship court leaves you in a very, very vulnerable place. Okay. This is a story. Of course, I've taken the identifying details out, but this is a story from my clients. They have a daughter who is an adult, and she just has had some mental health issues across her life, but she's an adult, right? At the end of 2024, they just could not find where she was. They were looking everywhere. They asked her roommate, except nobody could find where she was. So they had to go beg the guardianship court to allow them to become her guardians. They put the court on notice as to the risks that came with like her mental health issues. And just to get established as guardians, they spend over $35,000 to just get put in. I had a conversation with them recently, and they told me the maintenance of this thing costs them about $20,000 a year to just be continuing to be guardians for their daughter. So another thing that's really important to understand is even our adult children can need us to step in, okay? The fact that you're an adult doesn't mean you're invincible. It's the complete opposite. The longer we live, the more risk we're exposed to. So try to remember that. It is a very expensive process as opposed to planning. Probate, okay. Probate is the court process here in Florida and any other state in which you may have assets that need to be administered. It's public here, okay? Every filing is something that can be easily gotten a copy of. You pay a fee, et cetera, to the clerk, you get it. People that you might want to actually come into play to be the actors might not be able to do so because of the bond. The whole system is designed for creditors first, okay? Creditors get notice first, creditors get to put in claims first, creditors have to get paid out before a single loved one gets anything. And if the planning was not done carefully, the wrong people are now allowed to come in and make chaos and raise their hand and get involved. This could be step siblings, this could be half siblings, this could be the estranged ex-wife that happens to be the heir of your child that died, all these things, okay? It is also, again, very expensive. There's no control over the timeline. I know some people hear like, oh, it's just like a year to do probate. No. Creditors' claim periods are open for 2 years. That's what the statute says. So that's minimum. It can be open for 2 years. And then so many times there's like a new asset or a new thing that comes up that has to be reopened. I had to reopen a 10-year-old probate case that somebody else had administered because they forgot this promissory note that the deceased person owned. All right. So that's probate for you. And I have a real story to share regarding probate. We don't think of our vulnerability on the day-to-day. We think we're going to be fine. We assume we're going to live for a very long time. And it doesn't become something that people start to accept in terms of their mortality until maybe they enter their 70s. Okay. I have a client whose father and stepmom passed away in June of 2025. They were murdered by a loved one. Totally unexpected. They didn't have any sort of estate plan in place. They lived here, but they have property in multiple states. Okay. The size of the estate is maybe about $1 million. She raised her hand to be the personal representative of her dad's estate. Okay. The judge said, you're going to pay a bond of $150,000. Yeah. My client is very fortunate because she's very wealthy. And it's not a huge estate. It's $1 million. Okay. But that can prevent many, many people from being able to act on behalf of their loved ones. Period. And we don't know how long this case is going to take because there's so many things at issue with a person losing their life unexpectedly. So things will not always be okay. All right. So some people say, okay, well, I went to a lawyer and I have a trust. And is that all I need? No. Trusts are wonderful tools. Okay. If they are created well, they can be great. But here's how a trust can fail you. The trust didn't have the required execution to actually exist after your death. I've seen that. I'm litigating that. The trust didn't have assets put into that. I've also litigated that. The trust did not have the information so that the person who expected to get assets next would get them. I've reviewed a trust where the husband and wife created it together. She thought she was going to receive the assets after his death. And she is nowhere in the aftermath clauses. Everything goes to her child and stepkids because it was improperly done. A trust isn't going to give any training to the people that are going to be administering things for you. Sometimes people just don't update it. They're like, oh yeah, I have a trust from 2005. Whoa, the law has changed since then. You need to make sure things are up to date. And sometimes there's just serious ambiguity, okay, where it says, and then distribute this to this and this to these people, but then like, I don't know, 4 paragraphs later, it introduces other people and it never had clarity as to what was going to where. DIY trusts are super easy to challenge. Poorly made trust, just invite litigation. I have a friend of mine who litigates trust administration, right? When they go awry, when they're not properly made. And they were handling an estate, it was just $400,000, okay? $400,000 is the value of an average house here in Florida. Their legal fee was over $100,000 to administer the issues presented for this person. And if any of you watch the Golden Girls, okay, I'm a huge fan of the Golden Girls. If you know Blanche, right, she always wanted to change and then she'd put different things on for all of her like gentleman callers. And that I want you to think of that when you think of a revocable trust. You can change your mind about the terms of a revocable trust. It's a difference between that and an irrevocable trust instrument, okay? For us, we use AAA, updates, strategy, education, advice, accountability, awareness. If you do not have these things, if your attorney is not going through these things with you, you are not being best served. Finally, right, I have advanced tax training. Only 0.02% of lawyers in the state of Florida have advanced tax training. Estates and trusts can have income taxes. Yeah, they're subject to it too. And if you don't understand or your lawyer doesn't understand, they can make really expensive consequences for you or for your family, okay? I want to address these myths very, very quickly, okay? Number one, only the wealthy can actually afford to mess up with their estate plans because they have enough family members with liquidity so that it's not a problem to have messed up a little. For the vast majority of American families, though, you can't afford to plan incorrectly or do no planning at all because many of your family members are just not going to have the liquidity to fix those problems. Two, the assumption that your spouse gets everything. That is not the case. Okay. I've had clients who were married to their spouse for 35 years and they ended up getting nothing because they died during the probate administration and the one asset that they may have gotten an interest in was completely tied up with their stepchild. They couldn't do anything. They couldn't use it to take care of themselves. A lot of people say also, I can't afford this right now. Okay, well, number one, obviously you're not going to have the $400,000 in your pocket to buy the house, not necessarily, or the, $60,000 to buy the truck that you need to get to and from work and so forth. But you make room in your budget for it because it's important for you. It's the same thing here. You have a responsibility to your loved ones to take care of this yourself. Putting it on them isn't kind. And putting it on them makes it 10 to 20 to 30 times more expensive than doing it yourself. Doing it as part of your planning. Okay, so again, that's the golden ticket so that you know, legacy planning session, I'm an advocate, talk to a lawyer, see who the right fit is for you. Do not let AI create this for you. Please don't talk to a door lawyer. They have absolutely no expertise in anything. And I've had to deal with door lawyers in lawsuits, and let me tell you, those lawsuits take so much longer with people that don't understand the procedure. So if you're the right fit, great. My team will tell you about something we call the critical risk factor worksheet so that you can start to see what's really important, critical to discuss, critical to acknowledge in your planning. Okay, so there's a little link. Julia will put a link there. And now I want to thank you. I want to thank you for being here with me. Okay, you care enough about your family that you want to understand the things that you're missing. I don't want you to lose everything to procrastination. I don't want you to lose everything to the courtroom. I don't want you to pay that involuntary tax to the state of Florida or wherever other state you might have assets. I want to see your family excited and proud that you did something that made it so much easier for them to transition in whatever it is that you left behind. And you took that weight off of them because you are irreplaceable. People are going to be mourning you, whether you're incapacitated or passed away. It's still a mourning, okay? And so doing proper planning is going to really assure that they have that weight lifted off their shoulders.